Hello. Good morning, good midday, good evening, whichever, pick your poison. Hello, Willie B. Hello, Blue Horizon. Anthony, good morning to you as well. Welcome in. I'm not, whoopsies. Hold on here. I'm a little bit on the struggle bus today. Can't quite get myself sorted out, but that's all right. There we go. Maybe we're sorted. We're like halfway sorted. Still morning in Washington. Okay. Hello. Is it Jill? Jill T54. Hello. Duchess. Hello. Well, welcome in, everybody. Now, a lot of you know we have gotten a lot of decisions out of the Court of Appeals recently over the last few days. Pretty major decisions, major. So I thought, well, let's start going through it. I was going to try last night, but I just didn't have the energy, unfortunately. But I woke up this morning and I said, let's do this. So I'm excited. Vancouver, okay, hello. Oh, a little on the struggle bus. Yeah, I know, for the win, exactly, VC. I know we're all a little bit on the struggle bus right now. So, when that happens, you got to just, pull out a book and read when you're on the bus and just kind of wait for things to get a bit better, which they will be. I have no doubt. No doubt in my mind. So, out of the cases I am going through over on the tube, I do have a case that I'm going through, and we've done the first part. So, part one has been done over there, and I will continue to pick up where I left off over there. So, that's been really fun. We're enjoying that quite a bit. Sorry, everyone, I'm just double checking here. The one I'm going through on the tube is the Newsom case involving the National Guard. All right, so if you're interested in that, I do have a part one that you can find listed under my lives over there. But we're going to need to do a part two, and I'm hoping to be able to do part two tonight. Fingers crossed that everything comes together. But I'm hoping to do this. This one is really good for the tube because there's some words in here that I got to be a little careful about. So that's kind of good. But I thought over here on the talk, in order to get through our cases here, happy Thursday, yes. Oh, yes. So we're going to do the Alien Enemies Act case. This is the one, everybody. This is the big one. So I would equate this to the presidential immunity case as far as importance goes. This case is so incredibly important. And of course, it'll be appealed to SCOTUS, but the judges here have written this out so well. I'm just not sure there's going to be anything for SCOTUS to overturn, but you just never know. This one I thought, well, let's dive into it here. Yes, it is crazy, but well, we'll keep going. Thanks, Joe. Yeah, these are my fun little nails. I've been lately, who else has decision fatigue? Anyone else? I can't even make a choice anymore. I can't even decide what I'm going to have for dinner. All I do is I look and I'm like, that's it. That's a hot dog night. It's been a hot dog night for 10 days because I'm exhausted from making choices. It doesn't even matter what the choice is. It's like I'm too tired to decide. So there's this die you can get, like, and you roll it and it says what kind of food, like pizza or pasta or whatever. And so you roll it and then whatever food is on top is what you make for dinner. And I thought that was genius. But my problem is I can't decide whether or not I want it. I'm so fatigued. Oh my gosh, VC, instant oatmeal, yes. And that was breakfast. Absolutely. Oh, I know. Burnt out, everybody. Oh yeah, pork and beans, really? Really? Oh my gosh, I thought I was the only person that ate pork and beans. Oh my goodness, you're my people. That makes me so happy. I do enjoy the pork and beans for sure. Frozen burgers, yep. Drained, so sleepy all the time. Yes. Mac and cheese, yeah. I tell you what, it doesn't seem no matter how much caffeine I'm consuming, I'm still just straight up exhausted. Just exhausted. So so I needed to really, Wisco. Really? Oh my gosh. See, I love you even more now, Wisco. Pork and beans. Yeah, man. Yeah, it's homemade automatically. Oh, I know, I know. Yeah, we love that too. So no amount of sugar or caffeine is working at this point. So, yeah. A Weezer song? I don't know. It could be. It could very well be. Yeah, it was a staple in the 80s. Now, yeah. Them's were the days, everybody. The one thing I think that a lot of people forget is that we went through a period of time in this country where we didn't have a recession going on, and that would have been about 10 years around the 80s. And because of that, we could do all kinds of cool stuff, like, you know, not worry about the world ending from that. It could end in other ways, but those were the good old days. Yes, vitamin B12 is my personal favorite. But yeah, absolutely. Right. Despite what legal dad says. I agree. I agree. Oh my gosh. Yes, legal dad. I don't know about you. Embarrassed her too. But yeah, so, you know, beans are important. Eating well is important. Doing what you can to laugh. Those things are all very important things to do. So, and then also keeping up on our cases here. So let me go ahead and write out the citation, but this is going to be, I'm not going to be able to make it through this whole case in one live. But I will say, don't be too worried because we don't have, the whole majority opinion is not 195 pages. And thank goodness, because that's a lot. They're just asking too much. But we have an opinion, and then around page 45, we have concurring and dissenting, and then we have another dissenting. So this whole stack here are actually the concurrences and the dissents. So the opinion itself is only about 45 pages, and so that's all right. We can do that. Yes. Oh, thank you so much. Really try and stay away from red meat. Yes. Well, I don't do red meat. I prefer to have questionable meat in the form of a hot dog. But yes. Oh my goodness. All right. I tell you what, everybody, the other thing too is the last few days I thought I was the funniest person on the planet, but I'm noticing it's just me laughing. So I don't know. Whatever. As long as I can laugh, that's fine, right? All right. Here we go. Let's get to business here. We have WMM, and I'm just going to use this one as the top case here because we have others similarly situated. So we're talking about class here that they've set out. And it's versus Mr. T. Rump here. And again, I've got to be careful. Here we are. I know the new community guidelines are going to be clicking into place here pretty soon. So we'll just kind of see what happens. We'll go with the flow and jump ship if we need to. So this is case number 25-10534. And this is the majority opinion I'll be reading here. So majority, and then I'll just write here for appellate opinion. Hopefully everyone will know what I'm saying when I do that. Okay. And then this came out on September 2nd. Okay. Yeah, we need the chuckles. Oh, the chuckles. They, yeah, you got to have that. Thanks. Thanks, Thanks, everybody. Last week. Stop bragging, John. Now, John, stop bragging. I do have a really hard time with red meat because I love cows. I mean, straight up, everybody. That's just how it is. I love cows, and I have a hard time with red meat or milk. So I'm an almond milk person. John, I don't think you're really sorry. No, I'm just teasing you. Give me a hard time. So I do. I adore cows. And actually, maybe I should use the cow pen today. Now I'm all inspired. Here we go. We'll use the cow pen. Hi. All right. So this decision came out September 2nd. And again, I think this is probably one of the most important cases coming out of the Supreme Court or coming out of the appellate court. So if you'll know, a lot of the appeals, the plaintiffs are winning and the administration is losing. And then when it gets bumped up to SCOTUS, it's anybody's guess. So we don't know which way SCOTUS is going to go, truly, because we just don't know. But this is the one to watch here. All right, so this is the appeal from the United States District Court. And here we've got the Fifth Circuit for the Northern District of Texas here. And we've got our judges, our circuit judges here as well. So we do have, again, a majority opinion. We do have some dissenting and some concurring. So there's a lot. We're the only mammals that drink the milk of another. Oh, I know, Grody. I'm not trying to judge the milk drinkers, but I'm a little judgy about it. You do what you want, but for me, I just, yeah. And then other people are like, well, it's not really milk if it's made out of nuts. I'm like, yeah, all right. All right, everybody. So I'm going to dig in, and for this particular decision, I'm just going to keep reading here. So moderators, if you need to get my attention, you know what to do. Just pin the comment. But other than that, I'm going to kind of try to keep on trucking through this here so we can make it through the most material. And then again, I will comment. But other than that, I'm going to kind of try to keep on trucking through this here so we can make it through the most material. And then again, I will do and covered here. How they milk almonds. Well, that's a national secret. Almond milk, yes, that's right. Yeah, we can't give away national secrets right there. Oh, tiny hands. BC. It's Mr. Orange's hands. All right. Enough of that. Here we are. This case is on remand from the Supreme Court. The litigation began after two of the petitioners, who are natives of Venezuela, were detained by immigration officials on the basis that they were members of a Venezuelan terrorist organization. All right, I do love the cow, but I need something bigger. I need a bigger one. It's too small. Hold on, where are we at? Do we want to do? Well, yeah, let's do green. Should we do green? There we go. Here we go. Sorry, had to get the wand. All right. So the petitioners filed for a writ of habeas corpus in federal court, alleging they were about to be removed to El Salvador under the terms of a March 2025 presidential proclamation. Now, proclamations are different than executive orders, but they fulfill the same destiny. All right. Same. All right. No. Oh my gosh. Everybody. There's nothing I can say about my pens that's not going to be misconstrued. All right. The proclamation was issued under the authority of a 1798 statute applicable only in the event of a declared war, an invasion, or a predatory incursion by a foreign nation or government, and it allows the president to detain alien enemies. Just in order to give you some frame of reference, 1798 was before Hamilton was unalived. So Hamilton was still living. All right, keep that in mind. Here, petitioners sought an opportunity to dispute that they were members in the organization and also to show the proclamation was unlawful. The petitioner's motion for a temporary restraining order to prevent the removal made an extraordinarily extraordinarily rapid rise to the Supreme Court, where the court granted a temporary injunction. The court then remanded the case for us to determine whether the factors for a preliminary injunction to block removal had been satisfied, and also whether the government's notice to these individuals of their removal satisfied due process. Now, here's a little side note here. When we're talking about that preliminary injunction, we're talking about the Winters test, all right? And then when we're talking about due process, we're talking about the Fifth Amendment, not the 14th. All right. There is scant Supreme Court authority on the 1798 statute. The first and only time the court has needed to analyze the statute prior to the 2025 presidential proclamation arose 150 years after the statute was enacted. The same question was posed in 3 cases over a 4-year period. Had the declared war, so World War II, and the president's authority under the statute ended? The first 2 times the answer was no, but the 3rd time it was yes. For now, we simply describe what each opinion held about the scope of a court's review. Remember, that's the big sticking point that the administration is doing on all of these cases, is saying the courts don't have jurisdiction to even hear them. The first no was in 1948, but importantly, the Supreme Court held that judicial review for the interpretation of the 1798 statute was appropriate. And this is the Luedecke case. I don't think I've done a full live on that, but interesting case. There was no suggestion that interpretation was a pointless endeavor, that a court could make its interpretation for the interest of legal scholars, but was prohibited from applying that interpretation to the facts before it. Further, the court held that the courts should review whether the detainee was, as required in the 1798 statute, an alien enemy 14 years of age or older. Then the Supreme Court in 1950 held that courts were to ascertain the existence of a state of war when the detention under the 1798 statute based on a declaration of war was challenged. And that is the Eisentrager case here. Again, these cases are where they're setting out jurisdiction, all right? Finally, in 1952, the court held that Congress's terminating its declaration of war had ended the president's authority under the statute. And this is the Jagler v. Carusi case, 1952, here. Interpreting the meaning of a declared war and whether one existed was relatively simple. Deciding whether there is an invasion or predatory incursion after we interpret those terms will be relatively simple. Deciding whether there is an invasion or predatory incursion after we interpret those terms will be that a governor's determination that an exigency requiring military aid has arisen was conclusive, and that's the Sterling case. Each of these cases is important because it's what the administration's been using in order to pull jurisdiction from the courts. But though the governor's decision that the state militia was needed could not be challenged, the court reviewed closely and rejected the governor's decision on how to use the troops because the evidence showed there was no military necessity, which, from any point of view, could be taken to justify the action of the governor. Let's flip back and hit our first footnote here. All right, where did it go? Scanning. All right, well, it's somewhere in here. We'll just fast forward. Earlier this year, the Supreme Court reaffirmed that courts must determine whether a person detained under the 1798 statute falls within the category identified in the proclamation. And that is that JGG case, which is huge. So these cases are making together like this really important set of precedent here. All right, on here, everybody. This is gonna drive me bonkers. That's really weird. All right. Moving on. We will discuss those and other authorities in more detail later. We state now that the case law we just cited and others we will review do not directly or unambiguously give us the answers to the Supreme Court's questions. Thus, judicial humility is particularly appropriate here. So this is where they're saying, like, we have to be careful and, err on the side of less rather than more. There's your footnote. Did you find the footnote? Where's the footnote? Yeah, I'm struggling. I missed that footnote. I know it happens to everybody, but do we see the footnote? Hello, Laura. And then I also need the ability to move past it. All right, so again, judicial humility means to be careful and be conservative as opposed to running all over the place. Our analysis leads us to grant a preliminary injunction to prevent removal because we find no invasion or predatory incursion, conclude on the current record that the updated notice satisfies due process, and remands for further proceedings. So this is the piece here. This court, now the Fifth Circuit, has come in and said, no, there's no predatory incursion, and your notice is fine. So due process isn't the issue, and we are going to remand this because, again, that piece is not allowable. The page before, near the bottom. All right. We're coming back in, everybody. Here we go. Oh, that's the wrong page. It helped if I had the proper page, right? Here we go. Flip. Here we go. Did we find it? All right. Seriously, I don't think this has ever happened to me before. This is the first time. I'm really sorry. I don't know why. I can't see it. It's hiding from me. It sets the tone for everything else. No. Okay. You know what, Kimber? I think they just forgot to put it in there. The second footnote 1 on the next page near the bottom was 1. A second pink highlight. The second one here. Oh my gosh, winning, everybody. Look at that. Oh, thank you so much. Oh my goodness gracious. I was going to really struggle on that. Thank you, everybody. Oh my gosh, I appreciate you all so much. All right, here we go. So again, this is huge. The Fifth Circuit is saying, look, we didn't have an invasion or predatory incursion. So boom, you're done. But your notice pieces did satisfy due process, and that's great. But to be clear, as to our ruling, 2 judges agreed that the revised notice procedures satisfy due process, at least based on the current record. So that's good for Texas, or for the government. We declare, as did the Supreme Court, that our injunction solely applies to the use of the war-related federal statute, does not impede use of any other statutory authority for removing foreign terrorists. And this was very carefully set out in the SCOTUS case, right? They said, we're not deciding any other issue. We're only looking at this one issue, very narrowed. And so the Fifth Circuit saying that's us too. We are only looking to see if this statute is allowable. not any other statute. And again, the war-related federal statute. And if we'll recall here a little bit of history, it was part of a set of laws, and the other three fell away, and this is just kind of the remnants. Factual and procedural background. The Alien Enemies Act, the AEA, adopted in 1798, authorizes removal of natives, citizens, denizens, or subjects of the hostile nation if there is a declared war with a foreign nation or government, or a nation or government is engaged in an invasion or predatory incursion of territory of the United States. Set out here again in the United States Code. President I gotta be careful here so I don't get hit by the TikTok here. So President Orange invoked the AEA to remove Venezuelan nationals who are members of this bad group, a designated bad group. The proclamation explained that the bad group is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. The bad group is undertaking hostile actions and conducting irregular WAR fare against the territory of the United States, both directly and at the direction clandestine or otherwise of the Maduro regime in Venezuela. Right? So that's the big issue, is that they are buddies with a person of power. Again, we're just reading through what that proclamation is. Now, there's two citations here. One is just stating, it's going to be out there. The other is the Federal Register piece. There were two petitioners when the complaint was filed. Both were held in the Blue Bonnet Detention Center in Anson, Texas, roughly midway between Fort Worth and Lubbock, Texas. They filed suit in the United States District Court for the Northern District of Texas under the provisions of 28 U.S.C. 2241. They will answer questions about my weaknesses. Whenever you get a question like, well, what's your weakness? I've always answered that I try too hard. I try too hard. Sometimes I work too much. There you go. You can use that. They sued on their own behalf and on behalf of all other non-citizens in custody in the Northern District who are or will be subject to the President's proclamation. No class certification has occurred. All right, now we found the next footnote. The district court denied class certification while this case was on appeal, but that order was automatically vacated by its own terms when the Supreme Court granted certiorari. And then we're looking at the WMM case, which was huge again, and the AARP case from SCOTUS. For present purposes, we treat the issue of class certification as remaining open. So they're not going to make a decision on the class certification. They're going to just leave that question open as it gets sent back. The district court denied their motion for temporary restraining order against summary removal under the AEA. Petitioners filed an emergency appeal to this court. We dismissed the appeal for lack of jurisdiction and denied their motion for injunction pending appeal as premature. I'm going to stop right here and remind everybody, all of these cases where they're coming back and saying that somebody's likely to win on the merits, sure, but that doesn't mean the case is over. And this is that example. They denied everything, would not give any help to the petitioners. And now they're coming back and they're saying, okay, we got to do this the right way. So all of their prior decisions were cast aside. The Supreme Court construed the petitioner's application as a petition for writ of certiorari from our decision dismissing the appeal. The court vacated our decision and remanded for further proceedings. The Supreme Court remanded for this court to address, 1, all of the normal preliminary injunction factors, including likelihood of success on the merits as to the named petitioner's underlying habeas claims, that the AEA does not authorize their removal pursuant to the President's March 14th, 2025 proclamation, and 2, the issue of what notice is due as the putative class's due process claims against summary removal. We preface our discussion with an acknowledgement that our opinions rely on, to some extent, on our independent historical research in order to interpret statutory language. If the Supreme Court grants review, the briefing there will permit the parties and amici to examine our efforts to understand and recount relevant historical events. So they're saying, we're going to give you some history here based off of our own research and what we know. And in time, if it's wrong, it's wrong, but we're doing our best. 1. Preliminary injunction. Petitioners argue the AEA does not authorize President Orange's proclamation and the government's notice did not satisfy due process. The Supreme Court advanced this case procedurally to the stage of consideration of a preliminary injunction. Quote, a plaintiff seeking a preliminary injunction must establish that he is likely to succeed on the merits and that he's likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equity tips in his favor, and that an injunction is in the public interest. So they're citing again, this is the winter test that we keep talking about. Also, I think it's good to note there have been several of these AEA cases that have gone up to SCOTUS and then been kicked back down. And one thing that Justice Jackson has been pointing out multiple times is their different opinions on what irreparable harm is. So this is kind of the piece that they are unable to agree on. We will analyze these requirements in that order. Sorry, everybody. I do have a drink. All right, there we go. We will analyze these requirements in that order. So here's A, the likelihood of success on the merits. Now, this is one of the most important pieces, so I will read through this piece, but I will probably fast forward through the other 3 pieces allowing for it, because that will come in later as well. The foundation of the petitioner's claims is that the president's proclamation cannot be supported by the authority granted him by the AEA. There's no argument before us that the Constitution would independently permit the detention or removal of individuals solely because they are citizens of a nation that's an enemy of this country, or even because they are members of a terrorist organization. Therefore, our obligation is to interpret a statute. Undoubtedly, a president is entitled to broad discretion if the statute applies. The point at which the court's authority ends and a president's unreviewable discretion begins is a key interpretive issue. So this is so important. I know just yellow highlighting it's like, man, that seems important. This is huge because in every single one of these cases, of which there are over 325, they are saying their case is not reviewable because it's within the president's discretion. So every case is using this. So the fact that the Fifth Circuit is coming out and clarifying this on the Alien Enemies Act statute is huge. This is just absolutely huge here. All right, so let's take a look. The president's proclamation relies on the following authority, right? So any of the cases with a proclamation or an executive order, whenever there's a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, that's kind of important. Just do that. And the president makes public proclamation of the event, all natives, citizens, denizens, or subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. Here, so, and then that's specifically in 50 U.S. Code Section 21, so the Alien Enemies Act piece here. The parties agree that as preconditions to invoking the AEA, there must be a declared war, an invasion, or predatory incursion by a foreign nation or government. There's no declared war, and the parties disagree on the scope of our review and the meaning of the other terms, quote, invasion or predatory incursion. So they're not agreeing on what those words actually mean. We also must consider how the phrase, quote, foreign nation or government affects the use of the AEA in this case. We start with the degree of review we can give to the proclamation. So let's just take a peek here. I may skip forward scope of review. I really want to hit the highlights that are key here. All right, we'll just keep going through it. I'm like, that's important. We need to look at that too. All right, sorry everybody, can't fast forward. This is important. All right, scope of review. The government contends the AEA grants the president a near unlimited authority to identify and countermand foreign invasions or predatory incursions. In its view, it is not for the courts to question the president's assertion that the actions of the bad group members constitute an invasion or predatory incursion by a foreign government. See that? You see what the court did there? They're saying the government says we don't get to be involved in whether or not we've got some kind of incursion or invasion. And that's a huge sticking point with this piece of law. Before reviewing the precedents on which the parties rely, we quote the Supreme Court's recent opinion discussing judicial review of this proclamation. Although judicial review under the AEA is limited, we have held that an individual subject to detention and removal under the statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, as well as whether he or she is in fact alien enemy 14 years of age or older. And that's again out of the Ludecky case. Under the proclamation, the term alien enemy is defined to include all Venezuelan citizens 14 years of age or older who are members of the bad group, are within the United States, and are not actually naturalized or lawfully permanent residents of the United States. And then we've got our citation here. Out of the Federal Register. And that was being pulled from the JGG case. All right, so Ludecky and JGG, those are some of the top cases here. Enumerating the court's categories, these issues are subject to judicial review. Number 1, proper interpretation of the AEA. 2, constitutionality of the AEA, and 3, whether petitioners are Venezuelan citizens 14 years of age or older who are members of this group, are within the United States, and are not actually naturalized or lawful permanent residents of the United States. So each of these pieces, I believe, are actually coming from the Ludecky case. All right, so the Ludecky case is like the courts have no jurisdiction except 1, 2, 3, 4. So here they're putting in 1, 2, 3, 4 as well. The constitutionality of the AEA is not being challenged, and the case has not reached a point where a decision is to be made on whether the proclamation applies to these petitioners. So we've knocked out 2 huge pieces here that the government's been arguing. First, you don't get to be challenging the AEA itself. And second, you don't get to decide whether or not the AEA applies to these people. And so they're saying, well, you're not even asking us that question. That leaves the task of interpretation. Of course, the text is the place to start with statutory interpretation, and at times nothing further is needed. Here, the place to start is not the unusual one. Is not the usual one. We must begin by deciding what the Supreme Court meant by interpretation and address arguments that our interpretive role is extraordinarily limited. Prior invocations of the AEA provide context as we seek to understand that role. Of significance for the historical understanding of the AEA is that its authority has been invoked only 3 times before 2025 Two occurred after, and the other just days before, Congress declared war on the nations covered by an AEA invocation. Those invocations were after war was declared in 1812 against Great Britain, after war was declared against Germany in 1917, and just before war was declared against the Axis powers in 1941. So, and they're citing an amicus brief here. So 3 times it's been used, right? So 1812 with Britain, and then we've got 1917 and 1941 against the Germany situation, all right? World War I and World War II. The easiest AEA decision from the Supreme Court Justice was by Chief Justice Marshall, writing circuit. So we're going to start getting into the history, everybody, all right? We're going into the weeds. In December of 1812, Marshall and a district judge in a habeas suit filed in Virginia Circuit Court by a person jailed under the AEA released the detainee from confinement. And you can pull this up here. The release was ordered because the alien enemy was to be held until an opportunity to remove him arose. But there was no place designated for him to be taken. Sound familiar, everyone? Thus, the first time the Supreme Court Justice considered the AEA, a careful review of the validity of an alien's detention was made. The identified flaw was technical, but judicial review led to release. Right, Doughboy. Right. Yep. That's right. Let's just double check that. We got to make sure we get our dates. And just before the war was declared against the Axis powers in 1941. The most useful judicial precedents on those prior invocations of the AEA occurred after World War II. The government's primary authority on the limits to the judiciary's interpretive role is the 1948 decision of Luedecke v. Wilkins, right? So still that Luedecke case comes back again. In that declared war case, petitioners argued the president's authority to employ the AEA during a time of war did not survive a cessation of actual hostilities via Germany's and Japan's formal surrender in 1945. The court refused, with 4 dissenters, to review the president's determination that a state of war still exists. The court's making its own determination would be assuming the function of the political agencies of the government. Here we go. It is not for us to question a belief by the president that enemy aliens who were justifiably deemed fit subjects for internment during active hostilities do not lose their potency for mischief during the period of confusion and conflict, which is characteristic of a state of war, even when the GUNSs are silent, but the peace of peace has not come. These are matters of political judgment for which judges have neither technical competence nor official responsibility. Yeah, all right. In Luedecke, the court explained that the AEA's terms, purpose, and construction leave no doubt that judicial review is precluded except for questions of interpretation and constitutionality of the act. Indeed, the act confers on the president very great discretionary powers that are as limited as the legislature could make them. Now we're quoting the Brown case out of 1814. Here, and then quoting the Lockington case out of 1817 here. We're going back, everybody. We're going way, way back. Such great war powers may be abused, but that is a bad reason for having judges supervise their exercise, whatever the legal formulas within which such supervision would nominally be confined. The full responsibility for the just exercise of this great power may validly be left where the Congress has constitutionally placed it, on the President of the United States. we conclude that Ludecky resolves one issue about the scope of our review. So this is good too, because they're pulling in this past precedence in the Ludecky case, and they're confirming how it has been used. They want to use it the same way again. So 1 second here. Let me just grab that Ludecky case here. Hopefully I can grab it. As long as my cats haven't eaten it. Da, 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 da. Okay, here it is. All right. So for anyone interested in the Ludecky case, which is really what's giving a lot of the teeth to this decision here, this is the Ludecky case, and it's 335 U.S., and it's starting on, what page are we starting on here? 160. All right, so this is the case they're talking about. This is just the summary up here, but if you pull this up as the summary, what they're talking about again here is the judicial review is not allowed under the Alien Enemy Act, but only in certain situations. In the circumstances of relations between the United States and Germany, there existed a declared war, notwithstanding the cessation of actual hostilities and the orders enforceable. Number 3, the Alien Enemy Act construed as permitting resort to courts only to challenge its validity and construction and to raise questions of the existence of a declared war and of alien enemy status does not violate the Bill of Rights of the federal Constitution. So this piece right here is setting out the parameters of judicial review. All right, and then number 4, the fact that hearings are utilized by the executive to secure an informed basis for the exercise of the summary power conferred by the act does not empower the courts to retry such hearings, nor does it make the withholdings of such power from the courts a denial of due process. So this piece number 4, we're not really getting, but they did do this with the schmatzis back in the day. And that was, instead of just walking around and being like, oh, you look like you're from Venezuela, here we go, they actually held hearings where they had evidence and made that clear. So these were kind of the first determinative hearings that they had, and that was allowable, and that was okay. And whatever decisions came out of those hearings, that's what was not reviewable by the courts. All right, everybody? So there we go. Right. So Ludecky's very important case for those of you following along at home. All right, so Ludecky resolves one issue about the scope of our review, which is very important. If judicial review is precluded except for questions of interpretation and constitutionality of the act, and we take that to refer to interpreting the statute's text and also applying the interpretation, then the president's fact findings are not within our review of authority. See how they're setting that out? Because again, in Ludecky, they had hearings. We don't have hearings here. But apparently the president has made some fact findings. And based off of Ludecky, that means those findings are outside of judicial review. For example, petitioners here have challenged the president's finding that the Maduro regime in Venezuela is directing the actions of the bad group in this country. We interpret the Ludecky court to have made conclusive the president's belief that certain categories of aliens are enemies and engaged in hostile actions. All right, so they're like, look, you've already made some determinations and we're not going to touch that under the Ludecky case. Thus, even though petitioners insist there is no basis to find the Maduro regime is directing that bad group action in the United States, it's not for the court to review a president's findings about the facts when he is employing the AEA. We accept all presidential fact findings about what events have occurred, including who is directing them. So this is really important here. All right, so the Fifth Circuit's like, dude, we respect what you're doing here, and we realize that certain things on this road using the AEA are outside of the scope of our jurisdiction. 1984, egads. Nonetheless, for us to defer to findings of fact, there must be findings of fact. That's a good point. The AEA specifies that the president must make public proclamation of the event, giving rise to his invocation of the AEA. Here under the statute. The statute does not identify what, at a minimum, must be included in that proclamation. And if you'll remember, the executive order did come out declaring the Bad People Group hostile incursioning against the United States. That EO, or executive order, was actually filed before this use of the AEA. So he was prepping it, getting things ready. We conclude that proclaiming without more that an invasion or predatory incursion has occurred will not suffice. Ooh, there we go. That's another piece of precedent. Very important here. All right. So he's like, look at my executive order. I'm saying there's an invasion. And the court is saying, no, we need more than that. We need something more than just you saying it in an executive order. This is like the trust me bro situation for the president. And the courts, that seems reasonable, right? Doesn't that seem reasonable to everyone? That something more than just a declaration? Like before, they were having hearings in Ludecky, right? So they were going through and making that record. But here, literally all we have is an executive order where he's declaring it. And in that executive order, it doesn't really set the parameters out. It's basically just saying because this bad fella's in charge of Venezuela and the bad groups are like doing whatever they want with the bad guy, now we're at war, right? So that's just not enough. It's not enough. We know this because the precedents require interpretation, which implies the application of law to facts. Thus, the proclamation must inform of what is believed to be occurring. Our role is then to see if those facts meet the meaning of the statute. And then we have the third footnote. So the court's actually doing a really good job here, right? So we've got precedent, we've got cases here. We'll just focus on Ludecky. We've got cases here where in order to make the determination, they had to have some hearings. They had to have some research behind it, some support. And that's what was needed for the Ludecky case. And so that's the most recent case. So why can't we have that here as well? And then we have footnote 3, to the extent that cases about the reviewability of agency action could provide analogies, they are not contrary to what we identify as the scope of our review. Although sometimes the best reading of the statute is to afford discretion, we are still to police the outer bounds of that discretion, not to abdicate the judicial role altogether. So this is, oh my gosh, everyone, this decision is so important. So what the judge is saying here is we're walking a fine line. We have to be very careful because we're not here to be like, wow, your president sucks. We've got to save the entire country from his bad business. That's not why the courts are there. The courts are there to interpret the laws. And I think as we're all finding out, our laws could be written better. Do better, Congress. So that's what they're saying here. They're saying, look, we're just talking about the laws and interpreting and getting those sorted out. If your law's rubbish, that's your problem, not ours. So the other piece of this here is they're citing the Loper-Bright case, right? Loper-Bright is the case that overturned the Chevron doctrine. Right? Remember when everyone's like, what's the Chevron doctrine? And all of attorneys are like, whoa, haven't heard that before. So that's the citation that they're doing here. So again, very important to distinguish between what power the courts have versus what power the executive branch has. Because the Chevron doctrine, Loper-Bright, had to do with the Administrative Procedure Act and those administrative functions of the executive branch of the president. Yeah, true story. Yikes. All right, so back in it. So that was the third footnote, although I didn't make the second piece. Here we go. Statutes can sometimes be read to preclude judicial review entirely, but there's a presumption in favor of reviewability that can only be overcome by clear and convincing evidence, and that's a standard of proof of congressional intent to preclude judicial review. So there's a level of proof required to show that Congress didn't want the courts to review it. So the courts have to review it in order to figure out if it's reviewable or not. I love that. All right, here's the second half of that footnote. So, of judicial review precluded despite the presumption, but in the next breath, it preserves judicial review of questions of interpretation. Again, citing that piece out of Ludecky, our scope of review is consistent with that holding, as we have explained here. So, does that make sense to everybody? Let me just do a moment here. Is everyone kind of following me here on this? Just wanted to make sure. Sorry. Yes. Okay. Yes, it's making sense. It's making sense. Okay. Okay, good. Right. So summary. Sure. So what the Fifth Circuit is saying here is they want to rely on prior cases because that's their job. The case they're relying on is Ludecky. In the Ludecky case, there is verbiage in there saying judicial review is not allowable. But then, as with all things in the law, they set out exceptions. So this court, the Fifth Circuit, is saying, all right, we see what you're saying. And so these areas are not reviewable, but these other exceptions are reviewable. And when we're talking about whether or not courts can review cases or review different pieces of law, we're going to need to look to the legislative intent and try to figure out if that's really what Congress decided. Because ultimately, Congress can say this is not to be reviewed by the courts to some degree. So they've sorted it out and they said, okay, fair enough. But we are following Ludecky. That's our precedent. We're not outside of the scope of our review because a couple of the big questions we're not going to even answer. All right. So there's your summary here. So let's make sure. All right. So we had the second part. I was reading here and then reading here. So let's bump back up to the top here. I was going to try to skip through this, but it's just too interesting. All right. So we're going to just go right through it. An acknowledgement and caveat. The Ludecky opinion involved a declaration of war, a formal announcement by Congress. Oh no, I've got the puzzle piece, everybody. Fingers crossed, fingers crossed, fingers crossed. Do we make it? Oh, we made it. Yay. That's like a win for me. That's such a huge win. I can do the puzzle piece. Oh, yay. All right, here we go. A formal announcement by Congress that one of the prerequisites for presidents invoking the AEA has occurred, even if a war undoubtedly exists, perhaps due to an invasion and an armed response by this country's military. But there has been no congressional declaration of war. The president would need to declare that an invasion or predatory incursion is occurring in order to use the authority of the AEA. Again, that's where we get into this executive order that this administration set out and just said, yeah, there's an incursion. They just wrote it on a piece of paper and it got published. Or on a computer and it got emailed. However they're doing it these days. There is almost nothing for parties to dispute as to whether declaration of war exists, but we will soon address one issue. Perhaps our understanding of the Ludecky's course holding about findings of fact would not apply in toto when the AEA is being used to respond to what the president believes should be labeled as an invasion or predatory incursion. That means this is the first time that the AEA is being used for the second piece, all right? The AEA has been used 3 times, and in 3 times we've had war declared. This is the first time where we've got this predatory incursion issue, and the first time the president's just saying, well, we've got one, as opposed to Congress or someone else setting out the parameters. If such a distinction is to be made, we leave it for the Supreme Court to make. And so they're like, we're not going to decide that issue. The unreviewability of the president's factual findings is a discrete issue, separate from whether the statutory label of the proclamation places on a finding is consistent with a court's interpretation of a statute. The needed interpretation is the meaning of a declared war, an invasion, or predatory incursion. More clarity about a court's role was added in a habeas corpus proceeding brought by a German national confined by United States Army in Germany. The court held that the detention was constitutional, but courts had authority to ascertain the existence of a state of war and whether he is an alien enemy, and so subject to the Alien Enemies Act. And that's the other case, the Eisentrager case out of 1950 here. That is a revised description of review from what Ludecky stated in that the existence of a state of war was explicitly mentioned as a valid subject. We conclude that the Johnson opinion means that a court was to assure itself that there was a declaration of war and that it had not been terminated. That issue arose in the next case. The final relevant precedent coming out of World War II was U.S. versus Jegler versus Carusi in 1952. Now, we remember it was 1945 when the war ended, all right, so this is a few years later. The court referred to the 1945 presidential proclamation under the AEA, seemingly still in effect, that had authorized the Attorney General to detain and remove alien enemies deemed by the Attorney General to be dangerous to the public peace and safety. And then we're citing that proclamation here, which was set out in 1945. All right, so we had, by the way, side note, everyone, I have been going through executive orders from George Washington all the way to today. There's some crazy business going on in those executive orders, and it's not just Mr. Orange. There is some crazy business going on in those orders. I was looking at one and I'm like, I'm sorry, what? What? We have to use silver bars, not gold bars? What are you talking about? All right, side note, there you go. The Attorney General used that authority to order a German who was a prisoner in this country to be removed to Germany, and that's the Jegler case. While the prisoner's petition for a writ of certiorari was pending, Congress, by joint resolution, declared the state of war between the United States and Germany at end. Now, they just went in and said it's over. Here's our joint resolution here. The court showed no interest in whether the president agreed that the period of confusion and conflict, which is characteristic of a state of war, was over. So if Congress says it's over and the president disagrees, it doesn't matter. We need more of that kind of language. We need more of that. Right. Oh, that'd be great if we could have more. Thanks. Perhaps the then President Truman would have disagreed. At least as to this AEA prerequisite, Congress itself could end its applicability regardless of the president's agreement. So this will be another pause to let everyone know. We have I think 5 or 6 declared emergencies right now in the United States, everybody. One of those is being used here for all of this rubbish with the Alien Enemies Act. Another one's the one allowing for all of these tariffs to be done. We have an electricity one. We have a lumber one. There are multiple emergencies that have been set out via executive order. You know what stops an emergency in an executive order? Congress. Congress can stand up any day of the week and say, the emergency's over, file it and send it through. And you're going to have to kind of dance a little bit with the executive branch, getting the executive branch to sign it. They could end all of these emergencies, which would end these executive orders. So just remember that when you're voting, right? That might be important to you, your call. The other possible foundational events for invoking the AEA, an invasion or predatory incursion, are for the president to determine. There we go. Here we are. Congress seemingly has no role because there are no Supreme Court precedents reviewing the invocation of the AEA on either of those grounds. We consider the following decisions in which the Supreme Court addressed the reviewability of executive determination in other contexts. So this is where things start getting crazy. They're saying here that the president can say, hey, we've got an invasion or predatory incursion going on. They don't have to have Congress involved. And so now they're going to look to how they know whether or not that's appropriate. All right, so they're going to set out some precedent. Yeah, I know, Congress. All right, here we go. One decision occurred, the Militia Act of 1795. Again, this is when Hamilton was still walking around causing trouble. The controversy grew out of the war of 1812 between the United States and Great Britain. What? That can't be right. Yep, it's right. Mott was court-martialed for not responding to the New York governor's calling out the militia, a call complying with the president's requisitioning troops from the New York for the war. The Militia Act, enacted 3 years before the AEA, provided that whenever the United States shall be invaded or be in imminent danger of invasion, it shall be lawful for the president to call forth such number of the militia as he may judge necessary to repel such invasion. So this is interesting because we've got this Militia Act tangling up here with the Alien Enemy Act. And as a quick side note, there were some huge problems going on with the militia in the country. How the militia was operating was one of the biggest reasons why the Articles of Confederation were trashed, because they needed some kind of continuity when it came to militia, because it was so many different groups, so many different orders, so many different kinds of training. So they had to kind of put it all together under the Constitution. The court recognized this power as limited to cases of actual invasion, or of imminent danger of invasion. Here, according to page 29 of the Ludecky case, in navigating that limitation, the court answered questions that are relevant here. So again, we're going back in time, everyone, to process this. If it be a limited power, the question arises, by whom is the exigency to be judged of or decided? Is the president the sole and exclusive judge whether the exigency has arisen, or is it to be considered as an open question, upon which every officer to whom the orders of the president are addressed may decide for himself, and equally open to be contested by every militiaman who shall refuse to obey the orders of the president? We are all of the opinion that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons. So this is important to note. So if you are voting for a president, it's not just for, funsies. The president's actually got some significant power here to do some significant military damage. Obviously, the decision was in a different context. The state militias were being activated at the president's direction in response to an invasion of the United States by Great Britain in 1812. The court was writing long after the 1815 end of war, but it was discussing a situation in which the country had been physically invaded by the British Army in what at times is called the Second War of Independence. Now, I've never heard that. That's crazy talk. The loss of which could have ended independence. I try to not look at the War of 1812. I pretend it didn't happen. All right, and then we've got our citation up here. We conclude that the Supreme Court, in interpreting the Militia Act of 1795, held that it was for the president's unreviewable discretion to decide that the circumstances exist that require the calling up of the militia, or in today's terminology, the National Guard. What? It all comes back together, everyone. The present day use of that authority is being litigated in Newsom v. Trump. It certainly is. Even if the Supreme Court precedent concludes that litigation with Mott unchanged, the need for troops as an immediate defense to an actual or threatened invasion is readily distinguishable for justiciability purposes from when residents of the country may be detained and removed. Now we've got footnote 4 here. Additionally, the Militia Act of 1795 was worded in a manner that more clearly gave unbounded discretion to the president. I hope this still isn't. Yikes. The act used phrases such as, quote, as he may judge and as he shall think proper, no fewer than 3 times in the section authorizing the president to call forth the militia. Yikes. This 1827 opinion concerning the Militia Act does not displace the on-point century-plus later Luedecke, Eisentrager, and Jegler AEA opinions. So these are the war horses right here. All right, these 3 cases. More helpful than Mott and much closer to Luedecke in time, the court considered whether the Texas governor had exceeded his authority under state law when issuing a proclamation declaring martial law in certain counties that were in a state of insurrection and having a brigadier general of the Texas National Guard take such steps as he might deem necessary to enforce the law. All right, so this is the moment when I remind everybody we have seen some crazy times in the country in the past. So here we've got a Texas governor saying that some towns were insurrectioning. And this is the Sterling case out of 1932, right? So what was going on in 1932? Well, Prohibition was a piece of that, along with the Great Depression. So there was a lot of stuff going on. And in Texas, the Dust Bowl, I'm imagining. The proclaimed insurrection was by a group of East Texas oil and gas producers. They always cause trouble. And the laws being violated were state regulators' limits on the amount of production. The Supreme Court recognized that by virtue of his duty under Texas law to cause the laws to be faithfully executed, the governor was appropriately vested with the discretion to determine whether an exigency requiring military aid for that purpose had arisen. Indeed, his decision to that effect was conclusive. The limitations of conclusive were then explained. So let's catch this. It does not follow from the facts that the executive has this range of discretion deemed to be necessary, incident of his power to suppress disorder, that every sort of action the governor may take, no matter how unjustified by the exigency or subversive of private right and the jurisdiction of other courts otherwise available, is conclusively supported by mere executive fiat. To be clear, the power being used was found in the Texas Constitution and statutes. An analogy was made in the opinion to the presidential power recognized in Mott. The court upheld an injunction against the governor. Quote, there was no military necessity which from any point of view could be taken to justify the action of the governor in attempting to limit complainant's oil production. Therefore, what was conclusive was only the governor's belief that circumstances existed that required military aid. The court did not enjoin the call-up of the militia. After leaving that decision solely in the executive's discretion, the court did not hesitate to say the executive's categorization of the events as an insurrection did not prevent the judiciary's enjoining to use the troops to enforce production limits for oil and gas. So what does all that mean? It just means that the governor of Texas did have the executive authority to call out whether or not bad things were happening and what would go forward. Of importance, the label of insurrection did not enter into the court's reasoning beyond what we just stated. For example, there was not discussion of any state statute providing that if the governor believes there is an insurrection, certain actions can be taken. Indeed, almost everything discussed in the Sterling opinion after stating the governor's belief that an exigency exists is conclusive, makes the use of the governor's military powers subject to judicial review. Sterling thus supports the proposition that when private rights are involved, as here, courts retain some role in judging the proprietary use of war powers. This is where I will stop for today here. So you might say, well, what do you mean private rights? So when we've got constitutional violations or legal violations and we're in federal court, it means some kind of federal law is involved. And here where they're saying, we've got rights privately for oil and gas that are involved. So the court here is saying, well, we need to kind of expand this area when it comes to the amount of power that the governor has. Okay. All right, with that, my friends, I will go ahead and pull us here to the conclusion of today's What the H is going on. What the hell? So again, this is just the very first part of the Alien Enemies Act decision. And I think, again, it's incredibly important. It's very well written, and it's written with an eye on the Supreme Court reviewing it. And I think that's very important. So I will continue to read through. This will take a couple of lives. So probably over the lunch hour is what's working best for this particular batch, because I also have the Newsom case, and that is what I will be doing on the YouTubeage. All right, so I'm hoping to be able to hop onto the Tube of You tonight to go forward on Newsom, or tomorrow. So one of those 2 days will kind of hit that next piece. So these two cases are going to just be every other time slot, but I do want to get through these cases. I think it's incredibly important. Keeping me safe. Oh, Carol, of course. Exactly. Anyone who's in, right. Oh, Kristen. My goodness gracious. Thanks, Jared. Thanks, Karma. Thank you for coming by. So hopefully, yes, my Tube of You name is the same as my handle here. And there's going to be some changes coming down the road. And I know I keep saying that, but, it's true. The timing is a little off, but next live is... So I'm hoping to go on the Tube tonight or tomorrow, depending on my health, and then always on Tuesdays. All right. So semi-sane. Wow, that's excellent. that's pretty good range, actually, if it's semi. So yes, the Newsom case I can only read over on the Tube, and then I will continue on this Alien Enemies Act case over here on the Talk. All right. So take care, everybody. Thank you for coming by. I really appreciate it. Have a good rest of your day. Hopefully it'll be nice and calm.